In this discussion, we are going to look at a defining moment in the history of the Indian nation when our constitution was made by a large group of leading politicians and constitutional experts in the country. The usual method of evaluating the constitution in terms of the results it produced can be dispensed with in this connection. We are trying to look at the history of how the Constitution was made, keeping in mind the compulsions, the problems, and the contexts in which the Indian Constitution was drafted between the end of 1946 and the end of 1949. You know how towards the close of 1949, 26 November 1949 exactly, the final draft was prepared, and that was adopted by the Assembly on 26 January 1950 to make India a sovereign democratic republic. The importance of the Constitution, however, can be grasped from the kind of liberal democratic political culture that it managed to nurture over time. Liberal democracy in India, of course, encountered several threats at different points of time in the history of the nation, but these threats, however, could be contained because of a certain respect that people in the meanwhile had developed for the Constitution, for the political processes which the Constitution or the makers of the Constitution, the founding fathers of the nation, at the time of the making of the Constitution had tried to ensure. That actually distinguishes India from a standard inheritor regime. There is an argument about how many of these independent nations actually inherited the administrative apparatus left behind by colonialism, the basic civil service, the police service structure that was retained for purposes of administrative convenience. One can actually understand why, for purposes of convenience, some of the administrative structures were retained. But the Constitution, in my perception, in my assessment, makes a very important difference because it creates a democratic polity. It remains faithful to the principles of liberal democracy, which the British, despite their claim about introducing the British principles of governance, the Westminster model, had never been able to implement.
Sir, to what extent did the experience of the nationalist movement influence the constitution making, especially by the Congress leaders?
Yes, that is an important question because that ultimately draws us to the manner in which the experience of the national movement itself actually made a very important impact on how this constitution was made. Certainly, one cannot actually dispute the fact that a very important inspiration certainly came from British constitutional ideas, British liberal ideas. But at the same time, one has to consider the fact that the experience of the national movement made a very important impact. For example, you look at the basic structure of the Constitution. You have a parliamentary system based on the Westminster model, divided into two houses, the Rajya Sabha and the Lok Sabha, the House of Elders and the House of Popular Representatives, elected directly, and the Rajya Sabha members elected by the members of the State Assembly. You have fundamental rights, 7 in number at that time, which were enshrined in the Constitution. It includes the right to equality, right to freedom, right against exploitation, right to education, right to freedom of religion, and right to property and right to constitutional remedies. But at the same time, you see incorporation of a clause which, under conditions of emergency, would restrict these rights. Now, how does one explain this departure from a liberal principle, from a liberal format in which these rights are actually accepted as fundamental rights? So one has to put it in the larger context of the kind of troubles that the interim government, which had been earlier formed in September 1946, how this government was facing problems of communal disorder, problems posed by the princes against the unity that the makers of the nation, of the constitution, actually visualized for the country. So if we contextualize such things, if we try to contextualize why alongside the fundamental rights certain directive principles were also introduced, why there was a certain thrust or certain emphasis on centralism, why did the centralist bias actually was introduced into the constitution by making it more unitary than federal, one has to put the constitution making process itself in the context. It is possible that this kind of centralism had not been useful for the future development of the nation. It created a certain kind of centralist bias that also stood in the way of a composite national development. The Kashmir problem, for example, has often been cited by constitutional experts, by analysts, as an example of how centralism can vitiate normal political development in the country. You have many people from the regions and the states frequently complaining about the excessive authority that the center exercises over economic resources. But these are problems which have evolved in course of time when the constitution came to be implemented. And I believe that such problems would keep on recurring, requiring solution according to convenience, which is why the Indian Constitution had to adopt several very important amendments. But it's a different story of how the Constitution had evolved over time, at times deviating from the principles espoused by the founding fathers of the nation. This kind of emphasis on context requires a closer look at the political culture of Indian nationalism. For example, secularism. Secularism is enshrined in the Constitution, not in the Western sense, as people say, but in the sense that the state was not going to discriminate against a person for religious reasons, on religious grounds. But this secularism was something which the Congress leadership learned through organizing a movement in which they had to bring in different people. This is ingrained in a movement which required to bring in different people within the orbit of the national movement. Secularism, of course, is a liberal principle. This liberal principle they certainly had learned from Western political discourse. But the point is that this Western political discourse acquired a specific Indian meaning when this came to be employed, or the language of this political discourse came to be employed to understand the complexities, the requirements of the movement that they were organizing. Let us look at, for example, the issue of federalism. The whole idea of federalism was also built into the Congress-led national movement for the simple reason that India, even in 1885, could not qualify to the status of a nation. There were disparate regions, and the mainspring of Indian politics lay in the regions. So it was important for the Congress to bring all these disparate regions together to create a composite national movement against foreign rule. So to some extent, this demanded a policy which would protect the distinctive cultural ambitions or the cultural aspirations of different cultural groups inhabiting in different regions. In the end, federalism to a large extent became compromised by the accent on centralism, but this respect for the federalist, pluralist character of Indian polity was ingrained in the national movement. The same can be said about the great emphasis that they put on universal suffrage. When their rights were insecure, when their right of political expression, their political rights were insecure under colonial rule, there was an urgency on the part of the Congress leaders to insist on the clear definition of certain political rights which would be inviolable. So that is the reason why so much emphasis was put on universal suffrage as a basic precondition of the Indian polity. When we talk about the nationalist political culture, we have to also consider how some of the provisions of the Constitution, which came to be adopted in 1949, began to feature in the constitutional discussion amongst congressmen from an earlier time. We have already talked about the Nehru Report that was drafted in the context of the Simon Commission as a kind of an answer to the Simon Commission, and in the Nehru Report, precisely these principles were enunciated. Federalism and pluralism was accepted, but there was also a greater emphasis on centralism, greater emphasis on the parliamentary model, etc. And also, the Nehru Report underlined the importance of inclusion of fundamental rights. So, it is not difficult, therefore, to see a certain kind of connection between the earlier discussions on the Constitution among congressmen by way of responding to British plans of constitutional change, the limits that the British tried to impose on suffrage rights, limits that the British tried to impose on the rights of Indians to control their own governance. So, in the process of reacting to such limited reforms that the British had tried to introduce in India in the late colonial period, the Congress idea of what an ideal constitution should be for independent India evolved and took a certain shape that came to be implemented in the making of the Constitution in 1946-47. By and large, there was a broad consensus among congressmen about how India should be a liberal democratic order. There were disagreements, but these disagreements came to be resolved through the discussions in the Constituent Assembly. Let us take, for example, the idea of the Constituent Assembly. The idea of the Constituent Assembly, which ultimately was formed in 1945-46 after partial implementation of the Cabinet Mission Plan, began to figure in the mind of the nationalist leaders from an earlier time. You can still go back to the Nehru Report, where the idea of a Constituent Assembly deciding on the future constitution of India was mooted. You look at the responses of the Indian leaders to several measures of reform that the British had suggested, the Congress would invariably insist on the creation of a Constituent Assembly on the basis of as broad a suffrage as possible, on the basis of democratic suffrage, and this Constituent Assembly was expected to decide on how the Constitution would take shape.
Sir, how far was this Constituent Assembly created on the basis of democratic principle?
That is, of course, a very important question, because it was not. It was representative, but it was not democratic. But you have to also consider the period when this Constituent Assembly was formed. An unambiguous, unequivocal statement came only with the Cabinet Mission. When the British were actually trying to wind up their business in India, they were more serious about the constitution of a Constituent Assembly. The Cabinet Mission suggested that without further delay, the Constituent Assembly could be set up by representatives of the provincial assemblies. By then the provincial elections had already taken place, and the members of the provincial assembly, along with the rulers of the princely states, were expected to send their representatives to the Constituent Assembly. So ultimately, these provincial assemblies sent their representatives to the Constituent Assembly. The princely states also sent their representatives, but after some amount of persuasion. So one cannot actually think of the Constituent Assembly as a democratically elected body in conformity with the principles that the Congress had espoused earlier regarding the creation of a Constituent Assembly. But one might actually say that it was fairly representative. And more importantly, the Constituent Assembly was intended as a counterweight to those forces which were trying to create division in India, whether these were princes or the Muslim separatist politics. Ultimately, of course, Muslim League succeeded in their scheme of boycotting the Constituent Assembly and eliciting the decision by the British to partition India. But that is a different story. Despite such opposition, the Constituent Assembly acted as the expression of Indian nationalism for the creation of an integrated, liberal, democratic India. By way of answering your question, one might say that the Constituent Assembly, despite the limitation, despite the fact that it was not democratically elected, managed to bring together people from different walks of life, people who are experts in the field, and the Congress tried to ensure that among their members in the Constituent Assembly, different people should have representation. So they sent out instructions to the provincial leaders to ensure nomination of scheduled castes, minorities, Anglo-Indians, a group of experts who would be able to assist the Congress in the drafting of the Constitution. So there was a keenness or a willingness on the part of the Congress leadership at that particular juncture to accommodate as many shades of opinion as possible in order to permit important debate on what should be the nature of the Constitution. You have also the princely states, the members to be nominated by the princely states. Overall, there were 389 members, 296 from British India, 93 from princely India. Out of these 296 members, there were 210 representing general constituencies. You have Muslim constituencies, Sikh constituencies, and Congress had 199 members from the general constituency, 3 members from the Muslim constituency. But as I said, Congress wanted to allow for the representation of different kinds of interests, so different communities in the Constituent Assembly, and they tried to ensure this. Given this kind of a situation, given this particular structure, the work of the Constituent Assembly once again needs to be contextualized, because there was a conscious effort on the part of the Congress to accommodate different shades of opinion. And in this larger context, the overall direction came from what is known as Nehru's 8-point statement about objects and purposes. Now you have this history of how the Constituent Assembly met in several sittings. Decisions were taken between, say, December 1946, when the first sitting was held, and April 1947. But in June 1947, the Mountbatten Plan was announced, and there was no hope for the Muslim League joining the Constituent Assembly. So ultimately, it became a Congress affair. Congress allowed some more people to participate, but it was a Congress affair. But the way the Congress leadership went on with this business is remarkable. They created several committees which deliberated on the different provisions of the Constitution that they sought to incorporate in the text. Important functions were assigned to experts. Expert committees were created which deliberated on different aspects of the proposed Constitution. A preliminary draft was initially prepared. Then a final draft was prepared by a committee under the chairmanship of B.R. Ambedkar, who was not a congressman. Congress allowed men like Ambedkar to play a very critical role in the Constitution making. Then there was a public debate preceding the adoption of the Constitution in November 1949. So there are some reasons for people to comment that this was basically a Congress affair. The Constituent Assembly was dominated by congressmen. Some experts were certainly chosen, but these experts had to work in close collaboration with the Congress representatives in the assembly. But the point is that if we look at the discussions that actually were going on in the Constituent Assembly, we can see how different shades of opinion actually came into play. Take, for example, the issue of centralism. Not everybody agreed with the idea that India should be such a unitary state. There were some Gandhians who, during the discussion and deliberation in the Constituent Assembly, came up with the idea that there should be Panchayati Raj at the bottom level and there should be a Mahapanchayat at the highest level of decision making in independent India. They were thinking in terms of a decentralized democracy according to Gandhian visions and were not in favor of the kind of unitary state that the constitution makers, including Ambedkar, were visualizing. Ambedkar's point was that in a country where there are so many differences, where local interest could stand in the way of imparting social justice, it was important for the constitution makers to strengthen the authority and the hands of the central government to ensure social justice. Take, for example, the question of rights. As we have said, certain fundamental rights were incorporated in the constitution by making a departure from the British tradition. It's a written constitution. And this insistence on codifying the rights, writing down the rights as fundamental rights, had something to do with their experience of how the British actually very systematically subverted the principles of rule of law. So there was an urgency on the part of the Congress deferring to the liberal principles to make provision for protection of individuals from the possible tyranny of the state or from the possible tyranny of groups and individuals. So there was provision made for the individuals to seek constitutional remedies against such kinds of oppression. But you have also a very interesting chapter called Directive Principles.
Sir, why was this Directive Principles necessary? Also, sir, what was the long-term relevance of this section which segregated certain objectives of the state from the Charter of Rights known as the Fundamental Rights?
Yeah, these fundamental rights were visualized as fundamental and justiciable. So fundamental that on the possible or on subversion or undermining, on cases of violation of such rights, the court of law could be moved. Directive principles didn't actually imply any justiciable rights. But if you see the long-term evolution of the constitution, the kind of welfarism that the Indian state adopted as a matter of policy, you can see a very important departure from these foundation principles once again from the early 1990s. But leave out these departures. But the way the evolution of India was visualized by the founding fathers of the nation conforms to the growing attraction that the liberals then had for a welfare state. So it was Nehru's idea that even if you are not including certain things as fundamental rights, you are going to set out the agenda for the future by enshrining them, by including them as directive principles that were to guide the Indian state in its making of policies in order to maximize welfare, in order to make provisions for the protection of minorities, protection of disprivileged groups. That is the reason why directive principles acquire some significance, and it was taken from the Irish Constitution. So the directive principles were concerned with social justice. It included, for that matter, a commitment to international peace, commitment to environmental protection, a commitment to education, commitment to welfare and all that.
Sir, what were the other questions that the Constituent Assembly addressed?
So apart from all the whole issue of centralism and this relationship between directive principles and rights, take for example a universal suffrage. On universal suffrage there was no consensus, or even if there was a consensus after a while, that parliament or the legislatures would be elected on the basis of universal suffrage. There were people who thought that for India an indirect system of election was better. for the constitution of the higher legislatures. They thought that universal suffrage should be relevant for the constitution, for the local representative assemblies, the panchayats, and the panchayats in turn, through a process of indirect election, set up the higher legislatures. Ultimately, this point of view had no takers. Ultimately, universal suffrage came to be accepted. But regarding the proposal by Ambedkar and others, the scheduled caste representatives and some women, to include the universal suffrage as a fundamental right, there was a problem. There was opposition. Rajagopalachari and Patel opposed that, and ultimately universal suffrage features as a separate clause, not as an aspect, as a fundamental right. You have, for example, differences over the right to practice religion, right to freedom of religion. So Ambedkar and others felt that just in the same way Ambedkar felt that universal suffrage was the only way for the empowerment of the disprivileged groups and empowerment of women, empowerment of scheduled caste and others, lower castes, people who are not privileged groups. So for their empowerment, Ambedkar thought that inclusion of universal suffrage as a fundamental right was necessary, not merely as an electoral law. But ultimately it featured in the constitution, but as I said, differently. Similarly, on the issue of right to freedom of religion, there were differences. There were debates, in fact, within the Constituent Assembly. Ambedkar suggested that this separation of the government from religion was not enough. In order to create a secular society, it was important to limit the right to freedom of religion only to right of worship. So the right of associations and organizations to carry on religious propaganda, to indoctrinate them or to proselytize them, was sought to be excluded by Ambedkar in order to create the foundation of a stable secular social order. But ultimately K. Munshi and others did not accept it, and what actually was introduced had a wider coverage. Apart from right of worship, it also included the right to organize religious associations and others, and which did not actually augur well for the Indian polity, but this is a different problem altogether. The constitution makers were not in a position to anticipate many of the problems that would happen later, and as problems appeared, the Indian state had to resolve these problems by following different kinds of policies. We are only interested in that particular moment when the constitution makers were trying to make a constitution by considering the problems that existed at that time, inspired by the ideas from which they drew their inspiration.